How does the Confrontation Clause challenge hearsay evidence? Imagine sitting in a courtroom and hearing someone's out-of-court statement used against a defendant. You might wonder, can that really be fair? Well, the Sixth Amendment's Confrontation Clause is here to make sure it is. It's a rule that protects a defendant's right to face the witnesses who say things about them. This means the person who made the statement should be available in court to answer questions. If they are not, then that statement might not be allowed in court. Hearsay is when someone talks about what someone else said outside of court. It's often used to prove what actually happened. But hearsay can be tricky because it's not the original person testifying. The Confrontation Clause focuses on a special kind of hearsay called testimonial hearsay. These are statements made during formal investigations or legal proceedings, mainly to establish facts for the case. Think of a police interview or a written report used to prove something. The rule is that if a testimonial statement is introduced against a defendant, certain conditions must be met. First, the person who made the statement must be unavailable to testify in court. Second, the defendant must have had a chance to cross-examine that person before. If these two conditions aren't met, then the statement can't be used against the defendant. This is because the right to face your accuser and challenge their story is fundamental. This idea was clarified in a Supreme Court case called Crawford v. Washington. The court said that testimonial hearsay is not automatically allowed just because it seems reliable. Instead, the defendant must have had a real opportunity to question the witness before. This ruling changed how courts handle hearsay evidence, making sure defendants can challenge the evidence that's used against them. For example, if a police officer writes a report based on what a witness said during an investigation, that report might be testimonial hearsay. If the witness is not available to testify in court and the defendant didn't get a chance to cross-examine them earlier, that report can be challenged under the Confrontation Clause. Expert witnesses also relying on testimonial hearsay when forming opinions. If they base their testimony solely on out-of-court statements that are testimonial and the witness is unavailable, the court might exclude that evidence. Non-testimonial hearsay, like casual remarks or emergency statements, is not protected by the Confrontation Clause. But even then, it can still be challenged under general hearsay rules. So, in simple terms, the Confrontation Clause makes sure that hearsay evidence used against a defendant is fair. It requires that testimonial out-of-court statements be tested in court through cross-examination. This protects the defendant from being convicted based on unreliable or unchallenged evidence. It's all about fairness and making sure everyone gets a chance to face their accuser and challenge what's said about them.